Good evening, everybody. It's Chris here from the Whistle Stop Cafe in Mirror, Alberta. And I forgot to test my microphone before I started, but it looks like it's probably working. So as an intro to tonight's webcast, which I feel is a pretty important one, I'm going to play a video that somebody sent me highlighting some concerns they had about the Alberta Bill of Rights proposed amendments that were tabled in the legislature last week. And just so you all know, I believe that this Thursday is third reading. So pay attention. And thank you, Dave, for the video.
The province of Alberta is on the precipice of losing 52 years of established rights and freedoms, and most have no clue. As some of you may have heard, there is a proposal to add reasonable limits to the Alberta Bill of Rights. On the surface, it may sound innocent enough. The problem, though, is that reasonable is a very vague word. What seems reasonable to one person might be unreasonable to another. The proposed amendment itself is being referred to by many lawyers as a Trojan horse.
In a few weeks' time, our UCP government will be introducing legislation to amend and strengthen the Alberta Bill of Rights, a document that has stood as a safeguard for our civil liberties and freedoms for decades.
For quick context, the Alberta Bill of Rights was created in 1972 to protect core rights that we all rely on: freedom of speech, assembly, the right to own property, etc. This document is meant to serve as a shield, ensuring the government cannot encroach on these rights and freedoms. A modified Alberta Bill of Rights could lead to limits on freedom of speech if a message is seen as unreasonable. It could also limit freedom of assembly if a peaceful protest is deemed too disruptive. Or what about public interest, national security, climate change, or the next thing they have planned for us? The truth is, once the language allows for reasonable limits, it gives the government broad discretion over when and how it applies those limits. The proposed changes are very well crafted. Quite genius, actually. On one hand, it appeals to a logical thinking Canadian with proposals like, quote, the right for an individual with capacity not to be compelled or coerced into receiving a vaccine. I mean, hey, who doesn't want that, right? However, the added fine print of reasonable limits makes the entire document worthless. As the saying goes, giveth with one hand and taketh away with the other. The Alberta Bill of Rights is a foundational document. It shouldn't be left vulnerable to subjective interpretations or shifting political interests. What makes it so special is that it shines in stark contrast to the Charter of Rights, which does include the words reasonable limits, by the way, a script repeated quite often during the 2020 and 2021 lockdowns.
Why are you guys doing this, man? Seriously, you guys don't care about the Charter?
The Charter has limitations.
Yep, Article 52.
The Charter has limitations.
If we want to maintain our rights, it's essential to keep them free from subjective limits that could shift based on political tides. Whether you live in Alberta or not, let's stand for an Alberta Bill of Rights that truly protects Albertans without compromise. The intentions behind this video is not to attack or advocate for any individual or political party, but rather bring this topic to the front of people's minds. Public awareness is our greatest weapon, which is why this video is necessary. Freedom dies in the dark.
Well, there you go. So thanks again, Dave, for putting together that awesome video. Now, Dave made this video before him and I had a chance to talk. And since then, I filled him in on a few things. So let me just get right to it here. So last week, the Alberta government did something that we wanted them to do. They tabled some amendments to the Alberta Bill of Rights, which would give us some protections against what happened to us in the last few years. Now, the problem, as I saw and many of you saw, was that the government thought it was prudent to enter in a Section 1 clause at the beginning of the Bill of Rights. And it basically says you have these rights are given and affirmed, except when demonstrably justified in a free and democratic society or something like that. So basically what they're saying is you have these rights until we think that it's appropriate that we take these rights away for whatever this reason is. Now, I am no lawyer. I'm not a legal scholar. However, I have been forced to dive into that subject because, well, my life kind of depended on it. My future depended on it. I've been in legal battles for a few years. I continue to be in courts in other matters, and I've learned a lot. And one of the things I learned is that what we were told when we were children in the schoolyard, when we asked, hey, can I use that tetherball? Or, hey, can I use that, whatever toy? People would say, well, it's a free country, isn't it? That's what we were told, and that's what I believed until I found out it wasn't true. It was an illusion. We have this beautiful Charter of Rights and Freedoms that hardly any other country has, and it's supposed to protect all of these rights and protect us against the government. Wrong. Section 1 of the Charter allows for an activist judge to take discretion to set aside your rights. And that's what happened to me. AHS came and they chained my restaurant closed. And I said, you know what? I have rights in this country. I have rights as a human being. And they said, yeah, but your rights, you only have rights unless it's reasonable for us to take them away. That's what Section 1 did. And that's what was in the proposed Bill of Rights. So we made a really big stink about this. I contacted every MLA, minister, and the premier that I was able to contact. And I said, you guys cannot pass this into law the way it's worded. And I explained why. Some of them pushed back and they argued with me. They said we needed to do this because if we don't, then we don't have any laws. And you want laws, right? Well, of course I want laws. I believe in the rule of law in a free and democratic society. But when the government can set aside our rights because somebody says that you might get sick or there might be a pandemic or something like that, we're in very, very dangerous territory. So I told them what I thought. And I didn't really get the response I thought I would. I thought I would get a response like, you know what? I'm going to bring this up and we'll talk about it and let's we'll figure this out. No, what I got was basically nothing. No, we have to do this. It's important. We're doing it right. They were doing it wrong. So I did a Facebook post and I basically said, I'm supportive of this government. I'm supportive of Danielle Smith. Most people know that. But I will not support her or the government if they go down this path and they take a step backwards with her Bill of Rights. I will not tolerate that. I won't tolerate any government at any time eroding our rights and freedoms any further. And that got a lot of traction, went viral on Twitter. It went all over Facebook. People were talking about it. I was getting texts from people that you would not believe asking me about this post. And eventually it made its way into caucus, and they talked about it. And eventually with with a whole bunch of other pressure from Albertans just like you, they decided, hey, we're going to put the brakes on this. We're going to look at it. We're going to think about these things. And they said to me specifically that there would be no Section 1 clause in the Bill of Rights when it came out. But I also got some insight that very few other people have. You might be wondering, why would the government try and sneak in? Let me just change this for a second. I feel like my head's too big. Why would the government try and sneak in this Section 1 in this Bill of Rights that's supposed to be more robust and protect us from the things that happened to us in the last few years? Is it because they're trying to take our rights and freedoms? Are they corrupt? Are they actually plants? Is this a psyop? What's going on? And the answer is always, almost always, it's the simplest answer. And the simple answer was the government was actually trying to do what they thought was the right thing to do. But like every other time they've tried to do something in the last couple of years, they didn't communicate it properly. Here's the problem. Here's the paradox of what we want as Albertans, what we've asked for as UCP members, what we voted into policy at the last AGM and this AGM. This is the conundrum. This Bill of Rights that you can see behind me offers us it affirms us some rights and freedoms that we already have that we currently don't have affirmed on a document like this. Our Bill of Rights, our Alberta Bill of Rights that we have currently doesn't have a lot of these things in here. This Bill of Rights you're looking at is as presented by the Black Hats group after about a year of working on this. These are rights and freedoms that we want affirmed so that the government can't do what they did. But we've also asked for some other things. We asked for stronger parental rights. We asked for, the Compassionate Intervention Act. We asked for some other legislation that, if you think about it, wouldn't stand the test with this Bill of Rights that's behind me. What do I mean by that? Let's look at this one. This Bill of Rights, it allows, or it affirms our right to informed medical consent and medical autonomy. That's awesome. We all want that. I don't want anybody to ever tell me that I can't get on a plane or a train or a bus, although that was federal. But I don't want anyone to tell me that I can't go into a restaurant and have a cup of coffee because I don't have a medical intervention that I don't want. I don't want that to happen again. So we need that affirmed in law. Okay, so I also, when I'm driving through basically any town in this country, I see people who have all but lost their humanity and they're just shells of the person they used to be. You go downtown Red Deer and you'll see them shooting up behind garbage cans. You see people struggling with mental health issues and addictions, and they are not getting the help they need. They're getting a warm place to go and shoot up and fresh needles, but they're not getting any treatment to deal with the underlying problems. Now, in an ethical and moral society, you would say, okay, well, we need to get these people into treatment so that they can regain their humanity. That's not what we do right now. We needed legislation to do that. We needed the Compassionate Intervention Act so that those people could be picked up and put into the treatment they need to kick their habit and get back to living their best lives. That's needed. That is completely contradictory with the informed consent and medical autonomy right, is it not? If that right wasn't conditional, we would not be able to pass legislation like the Compassionate Care Act. You want parental rights. You want, as a parent, to be the one that makes the decisions on to the best interest of your children. Well, what if you're a parent and you want to, say, sacrifice your children to the woke agenda, and you want them to have bottom gender reassignment surgery when they're 14 years old? Well, that's a parental right, and it's going to be enshrined in the Bill of Rights, correct? That wouldn't stand either. You can't have a piece of legislation that says parental rights are affirmed by the government and respected all the time, and then also have a piece of legislation that says children under 18 cannot receive gender reassignment surgery because it's a life-altering decision. Do you see what I'm saying? The government, in their infinite wisdom and lack of communication, placed them squarely in this conundrum, and it's their own fault. It is their fault. They should have communicated better. They should have thought about this better. They shouldn't have to rely on people like me or you to point out these obvious flaws in what they're doing. They rushed this Bill of Rights out. They put the Section 1 in there thinking, oh, this will alleviate these problems that we're going to face with this other legislation, and it backfired on them. Because you and I do not want Section 1 type wording in a document that's supposed to protect our rights and freedoms. So you see where we are. If the government passes it in the form that they presented it last week, we will have taken a huge step backwards, as Dave mentioned. Those rights and freedoms that are affirmed under the Bill of Rights, which currently doesn't have the notwithstanding clause, they would mean little to nothing, because an activist judge, as what happened to me, could simply say, I take judicial notice of climate change. Your right to mobility is set aside. You can't drive your car anymore. Or how about this one? I take judicial notice of climate change, so I'm going to order you to stop your ranching operation as per Bill 293. You get where I'm going with this? I believe in my heart that our current government, under the leadership of Danielle Smith, actually wants to protect Albertans. I believe that. They see the same things coming down the pipe that we do. And they're trying to put things in place that can protect Albertans from what's coming. You see what's coming. I see what's coming. You don't think they don't see it? They see it. And they feel it. Right now with another little kick in the ribs from our Minister of Environment and Climate Change, Mr. Stephen Guilbeault, says that we have a cap on our oil and gas production. Oh, sorry, cap on the emissions, but that really is a cap on production. And our government is doing everything they can to try and protect us from that while managing our rights and freedoms. Or, pardon me, our desire for rights and freedoms. So what do we do about this? First of all, you contact your MLA, you make a lot of noise, and you tell them that you will not tolerate a step backwards with our Alberta Bill of Rights. You tell them, we will not be okay with Section 1 of the Charter wording. And you know what? I'm not gonna read Section 1. Go ahead and Google it. Charter Rights and Freedoms, Constitution Act 1982, Section 1. You'll see what I'm talking about. We won't tolerate that. And if you do it, you're gonna pay. You're gonna be fired. Okay. Second thing, start thinking about solutions. How do we manage this paradox that's been created by our government? Well, I have some answers. Over the last 4 days, I've been working on something that I want to send to the Premier and the Minister of Justice and our MLAs. I want to share my opinions and offer my solution that I think maybe would work. But first, I need to explain something. When you live in a society like we do, when you live in a free and a democratic society, there are times when a person may have to accept their rights being limited in certain situations. For example, we have a right to participate in democracy. There might be times when we can't participate in democracy because there's a war or something along those lines. Aliens have invaded and stolen all the ballot boxes and hid one, like the one that they just found in BC full of ballots. That was weird, right? Or some other examples that I'm going to get into. But my point is, I think it's prudent that we identify which rights and freedoms we will never, ever allow the government to interfere with, and which ones we're willing, as members of a civilized society, to sometimes set aside or allow to be changed slightly in very, very extreme circumstances with a very, very tough criteria to do it. Now, I really don't want that, but I don't see any other way to deal with this problem. So let me get right into this. I'm just going to read this to you. It's probably going to take about 10 minutes. So if you can spare 10 minutes of your day to listen to my solution that might affect the rest of your life, then please do. If there's something more important like a hockey game, or they still play hockey? I don't know. They still play hockey? Does anybody have any like box seats for hockey games or something? I don't know. I don't have them, but when it's beside the point. Give me 10 minutes. We're going to read this. I'm going to read this to you. And I want you to put in the comments, I want you to tell me what you think about this. And if you like it, I want you to suggest that I send this. Well, I'm going to send it anyway because I'm not beholden to anybody. And this is my thoughts and my opinions and nobody else's. So I'm going to send it. So here we go. Are you ready? You should get comfortable because this is going to take like 10 minutes. I'll let you get comfortable. This tea, by the way. Here we go. So this document that I've written with the help of ChatGPT, of course, because spelling, grammar, sentence structure, that type of thing is more important. It reads, Premier Smith and Minister Amery, as a citizen deeply invested in the civil liberties of all Albertans, I have first-hand experience with the legal and judicial system. That's true. You've seen it on the news. Which has underscored the need for reform. Rather than merely voicing concerns, I offer my thoughts supported by historical examples and a foundational understanding of the law for your consideration. I hope your administration will be remembered as the one that safeguarded freedom and prosperity for all who live and work in Alberta. Section 1, Foundational Principles of Rights Protection. This one is very, very important. The principle of good faith. So in the proposed Bill of Rights, 1.2 reads, no right or freedom under this Bill of Rights, freedoms, and responsibilities may be exercised with the intent of injuring another or in an unreasonable manner, and therefore contrary to the requirements of good faith. This clause ensures that rights are exercised responsibly and not used to harm others. It maintains a balance between individual liberties and societal safety. For example, I have the right to thought and expression. I have the right to say things. If I say things with the intent to hurt somebody, for instance, if I have a competing business and I tell people that the other business stole money, retirement money from seniors and used it to buy a restaurant, that is acting in bad faith, and that type of speech should never be protected. You understand what I'm saying? That was intended to cause harm. We cannot do things with the intent to cause harm. Otherwise, we're not covered by the good faith clause of any constitutional document or Bill of Rights. So getting on with it. Intrinsic rights. The rights enshrined in the Alberta Bill of Rights are not granted by government. They are inherent and belong to the people as part of their human dignity. They are our property. These rights are owned by individuals, and any interference with them must be justified as necessary measure, consented to by the people for the greater good of society. The government works for us, and we only give up rights if we say so, or if we allow them to take them. Do you understand what I'm saying there? It's our choice. So what we do now is very important. Inalienable rights, rights that are fundamental to human dignity and cannot be suspended under any circumstances. These rights are intrinsic because they are essential to the individual's existence and freedom. Inalienable rights, freedom of thought and conscience, freedom of religion, freedom of expression and free speech, right to life, liberty, and security of the person, freedom from discrimination, right to privacy and confidentiality of health information, freedom of assembly and association, right to legal counsel, presumption of innocence. Now, to be clear, I separated these into different categories. If you disagree with me, please put it in the comment. I would be happy to hear from you. Under conditional rights. Conditional rights are rights that may be limited under specific extreme conditions with substantial justification. These rights remain intrinsic, but may be restricted to protect public safety, maintain order, or ensure justice. For example, tricky one, the right to informed medical consent. Let me explain. Example, the Alberta Mental Health Act permits involuntary treatment in cases of severe mental health crisis. Under the ABBOR, which I call the Alberta Bill of Rights, such actions would need to pass judicial scrutiny to confirm immediate danger and a proportional response, with an automatic third-party review to prevent misuse of authority. However, vaccine choice is not conditional and must be protected as an inalienable aspect of medical autonomy. So I kind of mixed that up a little bit. I started off by talking about the current Alberta Mental Health Act, and then I kind of went into what it would look like under the proposed Bill of Rights amendments. So I hope that was clear. Next, freedom of mobility. Conditional right, in my opinion. Example, legal measures such as restraining orders and probation conditions can restrict mobility to protect others or enforce legal compliance. The Alberta Bill of Rights would require such limitations to be justified and narrowly applied with evidence. Now, when I refer to the Alberta Bill of Rights, I'm referring to the Alberta Bill of Rights as presented and proposed by the Black Hats Group, the document that's behind me. So this would be the amended Bill of Rights in its entirety. Moving on, parental rights in child health decisions, in my opinion, need to be conditional. Why? Because, for example, the United Kingdom's Bell versus Tavistock in 2020, that case showed that parental rights cannot extend to irreversible medical treatments for minors. Irreversible medical treatments for minors include gender reassignment surgery. The Bill of Rights would ensure those rights are balanced against the long-term welfare of the child. So you see the conundrum we're in here. Property rights. Example, the Civil Forfeiture Act allows for confiscation of property linked to illegal activities. The Bill of Rights would mandate judicial review and fair compensation in eminent domain cases. So again, the proposed Bill of Rights. The right to bear arms, conditional. Example, regulations ensure that the right to bear arms is balanced with public safety. The Bill of Rights would maintain the right, but include strict conditions to prevent misuse. Conditions like, training, that type of thing, probably would be appropriate in that case. Freedom from surveillance. Example, surveillance for national security must be justified, not like the type of surveillance that the Canadian government did. Hold on. thought someone was trying to come in the front door, but it was my cat reaching up and trying to open the door so he could get out. What a smart guy. Back to freedom of surveillance. Surveillance for national security must be justified, not like what the government of Canada did when they tracked your cell phone to see where you were going so that they control the spread. Do you remember that? It was not a national security concern. You didn't give consent. You never agreed to allow the government to infringe on your rights like that, but they did it anyway. The proposed Alberta Bill of Rights would protect against that, mandating oversight to ensure privacy rights are protected. The right to self-defense. Example, in RV Lavalley 1990, self-defense was scrutinized to ensure the use of force was reasonable. The Alberta Bill of Rights would enshrine the right with conditions to prevent excessive harm. So you can't say, well, I was just acting in self-defense after you beat the living daylights out of somebody for waving at you or something. That would be a disproportionate response. So there has to be conditions attached to the right. You see what I'm saying? It can't be an inalienable right, because anybody could just claim self-defense, beat the living crap out of somebody, and be protected under the Bill of Rights. That would be very dangerous. Access to government services. Example, natural disasters like the 2013 Alberta floods disrupted access to services. The Alberta Bill of Rights would protect against penalties for missing deadlines due to service unavailability. That's just my thoughts, by the way. Right to democratic participation. I mentioned this before. Example, 2021, horrible example. 2021 Newfoundland and Labrador election postponement due to COVID-19 demonstrated how this right can be temporarily limited during emergencies, although it would have been prudent to prove that the emergency was justified in the first place, but, bygones. The Alberta Bill of Rights would require clear criteria and transparency for such actions. So the key proposal here is that the Alberta Bill of Rights should distinguish between inalienable and conditional rights, protecting the former unconditionally and allowing limitations on the latter only with substantial justification and rigorous oversight. Section 2, case studies in historical context. So I wanted to kind of get an idea of where the failures and successes were with our current laws and our current charter. So here's some of them. Number 1, the 2021 conviction of Mr. Scott. I know that guy. Background, Mr. Scott was convicted for organizing a protest against COVID-19 restrictions. Despite arguing for his charter rights, the court set aside those under Section 1 of the Charter. Analysis, broad public health measures without sufficient proof of necessity or proportionality led to rights being unjustly infringed. How the proposed Alberta Bill of Rights would help. Under the proposed Alberta Bill of Rights, such measures would require court-reviewed proof of necessity and proportionality with defense costs borne by the government. Now, we're going to get more into that a little bit later. Number 2, AHS mandates on businesses during COVID-19, as an example. Background, Alberta Health Services implemented mandates requiring the closure or significant restriction of many businesses. I'm not answering the phone right now. Are you kidding me? During the COVID-19 pandemic. Neither AHS, the CMOH, or Cabinet conducted due diligence, relying instead on external sources for guidance. The closures were not debated, industry was not consulted, and empirical evidence justifying the restrictions was lacking. The economic and social impact. Between March and May 2020, over 8,500 businesses in Edmonton and surrounding areas ceased operations. Retail sales in Alberta dropped by 30% in April 2020. Additionally, EPS, Edmonton Police Service, reported a 31.6% increase in domestic violence cases in 2020, and there were long-term mental health implications linked to the restrictions. Legal developments. In July 2023, Justice Barbara Romaine ruled that some health orders exceeded the scope of the Public Health Act, as they were issued by politicians rather than the CMOH. This decision has paved the way for an expensive class action lawsuit against the Alberta government, spearheaded by Rath and Company, to hold the government accountable for economic damages suffered by businesses. Implication for the Alberta Bill of Rights. This case highlights the importance of embedding provisions in the Alberta Bill of Rights that mandate rigorous judicial review before implementing rights-limiting measures. Such oversight is essential to balance public health objectives with the protection of individual and economic freedoms, and prevent overreach that could lead to significant financial and legal repercussions, not only for Albertans, but also for the government, which also is financially burdening for Albertans again. So this is a twofer on this one. I've said right from the beginning, if the government had actually proven to me that what they were doing was necessary, closing my business was going to help, and this was the only path forward, I would have submitted to that. But they never did that. They never even tried. They just said, do it because we told you to, judicial review, look at the legislation, says we can do whatever we want. That's not okay at any time. And they did that, by the way, under the existing Bill of Rights with no Section 1. So we need some extra protections in here. Another example is the G20 protests in 2010. During the G20 summit in Toronto, over 1,000 protesters were arrested, many without sufficient justification. The protests were met with aggressive police action, leading to widespread claims of unjustified detentions and violations of the right to peaceful assembly. Wait a minute, didn't that happen in Ottawa too in 2022? I think it did. Pretty sure it did. The lack of judicial oversight and the broad use of emergency powers led to significant rights infringements, including unlawful arrests and detentions that were later criticized by human rights organizations. I think that happened in 2022 as well. In the aftermath, the Canadian government faced multiple lawsuits, and various reviews criticized the police handling of the protests as excessive and unjustified. Wait a minute. I think that's happening right now. The Alberta Bill of Rights would ensure that even during high security events or public emergencies, rights limitations must be demonstrably justified with judicial review and proportional measures. The safeguard would help prevent such overreach and protect citizens' rights to peaceful assembly. Again, this is all my thoughts and opinions. This isn't a legal scholar. I'm not a lawyer. This is just how I see these things. Feel free to disagree with me. Successes. R.V. Oakes, 1986. You may have heard of the Oakes test. Reinforced that rights limitations must be necessary and proportionate. How the proposed Alberta Bill of Rights would be affected. The Alberta Bill of Rights embeds these principles, ensuring provincial laws meet similar high standards. Another example is the Saskatchewan Federation of Labor versus Saskatchewan in 2015. You might remember this. The significance is it protected the right to strike as part of the freedom of association, which could also protect the right to protest. How the Alberta Bill of Rights would help. The Alberta Bill of Rights would codify these protections, ensuring government measures that impact collective freedoms meet strict scrutiny. You know, that's really all of any of us wanted throughout this whole thing. You know, show us the evidence and prove to us that what you're doing to us is necessary and will comply. But they never, ever did that. And if we put protections like this, enshrine it in an Alberta Bill of Rights, think of all the trouble and heartache and money and death and harm that would have been saved, if only. Moving on to the case of Sheila Annette Lewis. Ms. Lewis' case highlights the need to protect medical autonomy as a conditional right. She was removed from a transplant list for refusing a COVID-19 vaccine despite evidence of natural immunity. This underscores the importance of judicial oversight because she died. It was a death sentence for her. The Alberta Bill of Rights would mandate such oversight and ensure that limitations on rights are justified, necessary, and reviewed by an impartial third party. The Alberta Transplant Board received multiple letters and emails and guidance from all sorts of people about this. Dr. Dennis Modry, a good friend of mine, spent hours, days advocating for Sheila Annette Lewis, telling these transplant surgeons, like, look it, we would have never done this before. He was a heart and lung transplant surgeon. Why are we doing it now? It's not necessary. It's not going to affect the outcome of the operation. Just give her lungs. And eventually they agreed, but it was too late. Had we had an Alberta Bill of Rights that prevented medical discrimination due to vaccination status, Sheila Annette Lewis may be with us today. Another if only. The key point here is the Alberta Bill of Rights would safeguard individual autonomy, ensuring rights are limited only when truly necessary and proportional. It was not necessary or proportional to refuse Sheila Annette Lewis lungs because she wouldn't take, dare I say, vaccination for something that she already had natural immunity to. Number 4. This is an important one, Mickey. The role of the Minister of Justice in Alberta. Current structure in Alberta, the roles of Attorney General and Solicitor General are held by the same individual. The Attorney General's primary role is to represent and protect the government's legal interests, while the Solicitor General's responsibility is to oversee law enforcement and protect the public's rights. This is a conflict of interest. The dual responsibility of protecting government actions while simultaneously advocating for individual rights creates a conflict. You ever wonder why there's nobody advocating for you within the government? This is why. This structure can lead to scenarios where the protection of government policies may overshadow the obligation to uphold the rights of individuals. Casey? Is that what happened, Mr. Madu? I seem to remember the previous Minister of Justice saying something like, this was never about health, it was always about control. He was the Minister of Justice. He was the Attorney General. He was the one that protected the government's interest in these matters. And he said it was about control and not health. The proposal for separation of those two roles. The Attorney General should focus solely on defending government interests and ensuring that laws align with legislative priorities. The Solicitor General should act as an advocate for public safety and protection of individual rights, ensuring law enforcement practices comply with rights protections. The rationale for this is that splitting the roles would enable more balanced decision-making, allowing the Solicitor General to challenge government policies when they risk infringing on rights and ensuring unbiased enforcement of justice. The key benefit here is this separation would help prevent potential conflicts of interest, fostering greater public trust, which is very, very severely lacking right now, ensuring that individual rights are not compromised in favor of political or government objectives. It was the government's objective to nudge you in the direction they wanted to go, and there was nobody to advocate for you except for the odd pastor or burger flipper. Unreal. Section 5, safeguards against rights infringements. To uphold the Alberta Bill of Rights and ensure that any limitations on rights are applied justly, the following safeguards are essential. The evidentiary burden is on government. The government must provide clear and convincing evidence before any limitation on conditional rights is enacted. Before. Actually, did you know that the Constitution even says that? The Constitution says that the government is supposed to go through the judicial process before they take any rights away, but there's other laws that they get around it with. This includes proving that the measure is necessary, proportionate, and the least restrictive means available to achieve its purpose. For example, if you're sick, you're quarantined, but we're not going to quarantine 4 million Albertans because there's 1,000 people who are sick. That is a very disproportionate response. And it was a catastrophe. Proof of necessity. Limitations on rights must demonstrate a direct, immediate, and significant need. Measures should be evaluated for their effectiveness and potential impact on individual rights. Implementation suggestion for this. Create independent oversight bodies to assess and verify the necessity of proposed rights limitations. So that would not be the government, by the way. Judicial oversight. And by the way, I think I missed the title for this. These are safeguards against infringements. I didn't miss the title. Judicial oversight. Judicial review must be mandatory before enacting any rights limitation, ensuring that such actions comply with the Alberta Bill of Rights. Implementation suggestion. Establish a fast-tracked judicial review process for cases involving urgent rights limitations to prevent delays while maintaining oversight. I believe that's very fair. One of my favorites here in ways to protect against rights infringements: cost of defense. To prevent financial barriers from impeding access to justice, individuals defending their rights should not bear the cost. The government should cover all legal expenses in cases where individuals are required to challenge rights limitations. Implementation suggestion, just a suggestion. Create a dedicated legal defense fund to support individuals facing infringements on their rights. Now, you might be saying, whoa, why does the taxpayer have to pay this? Why does the taxpayer have to pay this? Because if the government is going to take action against anyone in our society or group of people in our society to keep that society safe and functioning, then it is society as a whole that should be bearing the cost because they are the beneficiaries of the action. Do you understand what I'm saying? Yes, the taxpayer should have to pay for that type of thing because the benefit is supposedly for the taxpayer. Now, you may not like it. You may think that that's greedy for people to ask that, they don't have to bankrupt themselves to fight for their rights like we do right now. But I believe that this is one of the most important and fair things that we could include in this legislation. And lastly, public transparency. The process and findings from reviews of rights limitations must be made publicly available to ensure accountability. For example, if the government tries to take away a restaurant owner's rights or a hair salon owner's rights or a pastor's rights, and they fail, that should be on the public record. So when you have the opportunity to cast your vote, you can fire them. Because who wants elected officials who attack people's rights without the justification to do so? I don't. And if there is somebody like that in our government, I want them out. So we need to know so we can make an informed decision come election time. So the proposed clause here, any infringement on conditional rights must be demonstrably justified in a court of law before enforcement, with the burden of cost and of proof resting solely on the government. Individuals shall not bear the cost of defending their rights in such proceedings. So, Adam Skelly, my hero from Etobicoke, Ontario, Adamson Barbecue, man, the work that man did to try and prove that what the government was doing was wrong is just mind-boggling. He had like dozens of expert witnesses, hours and hours of research and papers and all sorts of things to prove that what the government was doing was wrong. He should have never had to do that. It should have been the government that had to provide the evidence to prove what they're doing was necessary. Okay, Section 6. Here's the fun stuff. Recommendations for legislative amendments. Number 1. These are legislative amendments, by the way. Mandate cost coverage for legal defense. To uphold fairness and access to justice, the government should bear the cost of legal defenses when individuals must defend their rights against public necessity limitations. Suggestions for implementation: create a legal defense fund, as I mentioned before, and automatic cost coverage clauses. Include provisions in the Bill of Rights that place the financial burden of defense costs on the government when individuals challenge rights limitations. That would have changed the world in this province and perhaps in this country if we had had those protections 4 years ago. Again, split the roles of Attorney General and Solicitor General. Current practice of one individual holding both roles poses a conflict of interest, as these roles serve fundamentally different purposes. This is longer than 10 minutes. Suggestions for implementation. Legislative amendment. Pass legislation that formally separates the positions of Attorney General and Solicitor General, defining their distinct responsibilities. Ensure that appointments to the Solicitor General position are based on merit and commitment to upholding individual rights. I could think of a couple amazing Alberta lawyers who would do a very good job in that role. Strengthen mechanisms for ongoing oversight include a provision that mandates regular reviews of legislation that limits conditional rights. Suggestions for implementation. Annual rights compliance audit. Implement a process where a legislative committee audits laws impacting conditional rights. Public and expert involvement. Engage experts and the public to ensure diverse input during audits. Sunset clauses. Integrate automatic expiration provisions in rights limiting laws to mandate reapproval after review. The reason I added public in the public involvement in the review is because there might be a time when all the experts agree that the public should do this, and the public says, you know what, thank you for your advice, but we don't want to do it, and we're the people, and that's our voice, and that's how it is. In that case, if the public as a whole was willing to accept the risks against the direction of the experts, that's the public's business and nobody else's. So they should have a say too. It shouldn't be experts telling you what to do. It should be experts advising and guiding, but the decision rests with the people in the end. Another one, educate and empower citizens. I've said it before, I'll say it again. The only pandemic we're facing right now in this country and across the globe is a pandemic of ignorance. People are ignorant to science, they're ignorant to civics, they're ignorant to politics, they're ignorant to how the structure of their life works. And until we address those things, people will continue to ask for the wrong things, vote for the wrong things, and do the wrong things. So, educate and empower citizens. Public awareness about rights is crucial for a robust democracy. They should teach this stuff in school. More than what they do. More than the, hey, Trudeau was great, he gave us Charter of Rights and Freedoms. No, there's way more to it than that. Implementation suggestions. Public education campaigns. Launch campaigns to inform citizens about their rights and legal recourse options. Accessible legal support services. Expand support services to help individuals defend their rights. Workshops and community outreach. Collaborate with community organizations for educational sessions on the Alberta Bill of Rights. Why are we not learning about our rights? If we don't know we have them, how can we ever expect them to protect us? Almost done. We need some safeguards for quantifying immediate threat. Objective criteria and professional assessments. Definition. An immediate threat should be a situation where qualified professionals provide evidence indicating a clear, present, and significant danger to individuals or public safety. Then you would require expert assessments and supporting documentation before any rights limitations are enacted. And again, this should be publicly available material so we know who to hold accountable if they're wrong. Defined timeframes. Any emergency limitation should have a set time frame requiring review and renewal based on evolving conditions. And I'm not talking about the timelines like what they did with the COVID measures in 2020 or whatever. That was ridiculous. All they had to do is say, "Oh yeah, we need another this, we need another that." That was totally bogus. There needs to be a real time frame that requires real evidence to continue. Laws should specify that emergency measures lapse automatically if not reviewed within a specified period. So lastly, review and appeal mechanisms. Mandate automatic third-party review of limitations on rights with options for individuals to appeal restrictions. Establish a rapid appeals process to ensure individuals can contest rights limitations efficiently. So, for this, the proposed legislative language would be something like, an immediate threat shall be defined as a situation where a person, assessed by qualified professionals and supported by concrete evidence, poses a clear and present danger likely to occur within 48 hours. Judicial review is essential to uphold the individual's intrinsic rights and prevent arbitrary action. Now, I don't know about you, but it's a difficult pill for me to swallow to even think that there are times when we need to allow the government to infringe on rights. Something happened last year. One of our legislators had a tragic incident in their family where one of their family members was killed by somebody that should not have been walking free. That person with those problems should not have had mobility rights. Because we failed as a society, as a legal, as a judiciary, all those things, as a government, somebody was harmed and lost their life. So yes, there are situations where people's rights need to be limited. They need to be removed. They need to be set aside. But certainly not because you refuse to wear a breathing barrier at a friggin' grocery store. So we have some thinking to do. All of us want all of our rights to be inalienable. And I've thought about these different things for quite some time, and I'm trying to figure out a way how we can protect these intrinsic rights that we're all born with, while making sure that we can protect people within our society. So these are my thoughts. These are my opinions. I would invite you to do your best to slog through the, what I've just read to you, and share your thoughts and opinions as well. I know this is certainly not perfect, but I'm done yelling and shouting about government doing things wrong. And I think it's time that all of us did our best to become part of the process and encourage them with ideas on what they can do right. So this is my attempt. So in conclusion, this presentation aims to guide the development of a robust Alberta Bill of Rights that preserves intrinsic individual rights while providing a balanced framework for conditional rights. By embedding the principles of judicial oversight, public transparency, and the evidentiary burden on government and cost, Alberta can protect its citizens' liberties and maintain public trust. And it's funny, I added a quote at the end of this before I saw Danielle Smith's latest awesome speech about what the federal government was doing, and another one about the Bill of Rights. And I ended with this. The essence of liberty lies in the protection of three fundamental rights: life, liberty, and property. And that's that. So, what did you think? Do you think this is something that people can get behind? Do you think that the ideas that I put forward strike a good balance between protecting our intrinsic rights and allowing infringement on our rights in the most extreme cases in order to maintain law, order, justice, and public safety? Do you think with what I've suggested that the government would have been able to arbitrarily close restaurants? Do you think they would have been able to arrest pastors and drag them down the middle of the highway? I chuckle every time I say that because I just can't believe I say that in Canada. To be clear, this isn't something that anyone has to sign. It's not a petition. It's just a collection of my thoughts. And my plan is I'm going to get this in the hands of as many MLAs as I can. I'll try and get it in the hands of the Premier. I hope that there's something in here that helps them with the very, very difficult job they have right now. Can you imagine the monumental challenge that our legislators have right now to try and give us the legislation we want, to achieve the outcomes we want, and make sure that our rights and freedoms are protected now and going forward? They do not have an easy job, and I wouldn't want to be in their position. So I think everything we can do to try and help them out and guide them and direct them is probably a really good idea. So I have, what time is it? I can't tell. I have a liver spot on my hand, but it doesn't tell me the time. What is it? 9:10. Good grief. I got to get to bed. Cinnamon buns come early. 5 a.m. comes early. I'm going to quickly scroll through the comments. I'm going to try and answer a couple questions if there's any there, but I really want to get to bed, and you're probably sick of hearing me anyway. So let's see. Thank you. Some people are saying thank you. You're welcome. My pleasure. I didn't do anything for the first 40 years of my life, civically or politically, and I think it's time to make up for lost time, because if we had done more earlier on and we had participated in our democracy, things might not be the way they are. But that's another if only. Ask Klaus what he thinks about it. You know what I have to say about Klaus Schwab? Children, plug your ears. Fuck that guy. Oh, I didn't give you long enough time to plug your ears? What? You say worse things than that? Kids, come on. You shouldn't be saying worse things than that, unless it's about Klaus Schwab. Get this. None of those idiots that want to strip our sovereignty away from us can do anything if we protect ourselves. If we support our legislators and we legislate protections against outside influences like that, we don't have to worry about Klaus Schwab and the World Economic Forum. We don't have to worry about the World Health Organization, because as an Albertan, you will have unconditional autonomy over what vaccines you take. How angry would they be? How hard are they going to push back against this to try and make it so that we don't get those rights affirmed in law in this province? How mad is Trudeau going to be when he realizes that his pet project investment in the lipid nanoparticles isn't making the money it used to, because there's 4 million people in Alberta that just won't buy their crap anymore? I think there's going to be some huge pushback to this Bill of Rights. There's going to be a lot of lies, and a lot of them are coming from the NDP. So if they're saying something, obviously, you know, the opposite is true, which is very helpful. Sorry, questions. Doesn't. Oh, yeah, the media. Oh, good grief. There's a really good point. I believe that this type of information and these solution ideas need to get out to as many people as possible. If people don't know, how can they make a choice? How can they influence or participate in democracy to achieve these outcomes if they don't know the outcomes exist? The media is not going to pick this up. CTV isn't going to call me and say, "Hey, Chris, you know what? Can we put your proposed solutions for this Bill of Rights conundrum in our on TV or the paper or something? Can we do that? Do you mind?" They're not going to. The only way this information gets out is if you folks share it. If you have a friend that's got a Facebook page with, 154,000 followers that, just doesn't support the Whistle Stop Cafe because I don't dox police officers, well, maybe we could get over that and they could share this solution, get it in front of more Albertans. Maybe we could even look at this document I've written and we could say, you know what, let's go. Let's get this in front of our MLAs. See what I'm doing? Yeah, it's fun, right? You can do some in the comments too. My point is, this stuff doesn't get out at all unless we do it ourselves. We have to do the work. We have to share it. We have to have individual conversations. We have to make Instagram posts and Facebook reels and what do you call it? X, Twitter, tweets, twats. Oh, that's the wrong word for sure. We have to put stuff on social media so more people see it. So feel free to share this. If you want to clip this and chop it up and make it into something smaller and easier for people to digest, fill your boots. If you're a content creator and you want to use any part of this while maintaining the ideas that and the solutions that I'm offering, go ahead. You can do anything you want with this video. It's yours to do. As long as you don't make it whatever. If you want to make it parody, just send it to me so I can have a laugh too. And with that, I'm going to end with this one. Alberta definitely needs its own constitution. You are absolutely correct. And would you feel better if I told you that right now, currently, there are a group of very intelligent, freedom-minded Albertans already working on an Alberta constitution? What if I told you that this Alberta constitution was almost done? Well, that's the truth. There are really good people in this province who are working very, very hard for you and for me and for our children and grandchildren. The Alberta Constitution is in the works right now. But first, we need to get this Bill of Rights done. Because if we can't get a Bill of Rights passed into law, how are we going to get a constitution enshrined into law in this province? It'll never happen. So let's do the work on this Bill of Rights, get it done the right way so that we have the best chance to keep and defend our rights and freedoms going forward. And then, before you know it, we will have the same conversations with an Alberta constitution. Big news here in Alberta. Good night, everybody. Should I play that video again? Nah, you can watch it at the end. Good night.